Just remember, when it's ready to use. So she and when we call them as a witness, I'm assuming we're gonna have to put them here instead of up there because she can't see them up there for one.
Right, well, I'm going to ask for this motion to be heard first.
So. Get her for him. The best option. We've never done this, so remember. Hopefully it'll work.
Deputy,
Yes, ma'am.
I need for you to go ahead and move the TV so that it will show the witness stand. Angle it so it will show the witness stand. All you have to do is just turn it towards a little bit more towards the
Judge.
on your left, the TV's left.
So she can-
Push it,
Do you see where I'm
push it
standing
in.
at? Do you see where I'm standing at?
Yes,
Would this be okay for the witness to sit right here so they could look directly into the screen? Or do you want-
defense.
Judge, I don't have any problem with that. That's fine.
And Judge, first, I actually, this is ADA Han, have just had a motion for continuance filed on this hearing.
Okay. So we will hear that first, where the witness is in the hallway or in the room, the back
Judge,
room.
he's in the room. Do you want him to wait in the hallway or,
He can wait in the back room.
okay?
Yes, there where the
Judge, he stepped out now.
do I have a copy of that motion for continuance?
Judge,
The motion has been forwarded to you by email.
Court is going to get on record. Court is going to call cause number 676-104, State of Texas versus Jaime Trevino III. Parties, please approach and identify who's before the court, starting with the state.
Ling Han for the state.
Frank McAvoy for Jaime Trevino.
Jaime Trevino here.
State, it will be only you, attorney ADA Linhardt Martinez.
Victor Hernandez is also sitting with me if you'd like for him to announce.
So, Victor Hernandez for the state, Your Honor.
Let the record reflect that Jaime Trevino III is in this court session with his attorney. For the record, the defense attorney and the ADAs are in person in the courtroom. The defendant, Jaime Trevino III, is via Zoom. Therefore, we are hybrid, and also the judge is appearing via Zoom. We're here for a motion to suppress. Is that correct? Defense?
That's correct, Your Honor.
All right. Defense, when and state, you're ready to proceed.
Judge, the state is actually requesting a continuance for this motion to suppress.
So is that a no? You're not ready to proceed?
Yes, Judge, state is not ready.
Defense, are you ready to proceed?
Yes, Your Honor.
All right. So state you're not ready to proceed. Have you filed a motion for continuance?
Yes, Judge.
Defense, do you have a copy of the motion for continuance?
Yes, Judge, I was provided a copy.
Okay, and you have had time to review it?
I have.
Okay. All righty, state, we'll go ahead and hear your motion for continuance. Proceed.
Judge, the Texas Code of Criminal Procedure, Article 29.035A requires that the court grant a continuance whenever the state or defense has been given less than 3 days' notice before the new hearing date. This hearing date, while the motion to suppress was filed in, I believe, January, nonetheless, this hearing date was not given until Thursday, August 18. That gives us 2 business days' notice, which is insufficient notice. Additionally,
Defense? Excuse me, state, anything further?
and Judge, this wasn't included in the motion, but the state would have concerns that may, just need to be talked out with whether Your Honor is able to really fully assess the credibility of a witness without being physically in the same room with them.
Anything else, State?
Nothing further from the state, Your Honor.
Okay. As, defense?
Good morning, Judge. Yes. So in rebuttal to the state's motion for continuance, I don't disagree with how the state reads the Code of Criminal Procedure. However, Your Honor, if you'll recall, and as the docket sheet would reflect, this case was called for trial on the 18th. The state was given notice, the defense was given notice that this particular case was to be called to trial. The defense did urge their motion to suppress at that time, which is, of course, the defense has the right to do that. We could have also chosen to run the suppression hearing with trial, concurrently with the trial. Your Honor granted the separate hearing for the suppression hearing and the suppression issues. Had this case not been set for trial, perhaps the state would be correct in their argument. However, the case was set for trial, and that means every and all aspects of the case both parties need to be ready to go. So with that, Judge, respectfully, I would ask that the court deny the state's motion to continue.
Defense, anything further on the state's second point?
Judge, I would ask that that Your Honor not consider anything that's not has not been tendered to the court and filed in written motion. I believe that would be in violation of the Code of Criminal Procedure. I don't know that, and to that, I don't know that any court has ruled on that issue. And I believe that probably would be a defense issue to waive the right. And my client is present on Zoom and doesn't waive the right to be present with the complaining witnesses and other witnesses in this matter. But I would ask that that's me just speaking, Judge. I would ask that the court not even consider that at this point. It's not in the motion for continuance.
State?
Judge, I feel like just a clear reading of the Code of Criminal Procedure doesn't make a distinction between whether or not a case is set for trial already or set for a hearing. It seems to me that the issues for a suppression hearing are necessarily going to be very different than that's required for a trial, which even just it being considered by a judge on issues of fact and law versus of a jury where they're going to be assessing chiefly, facts and then trying to apply the law, perhaps, then it just seems to me that this is very clear cut. This was set with 2 business days notice. It is not sufficient notice.
Judge, if I might,
Hang on 2 seconds. Go ahead, defense.
Thank you, Judge. If I might, the state would have needed their witnesses today if the court called this case to trial today, as it originally was set for trial. The idea of whether or not a jury is present is irrelevant, Judge. The court is the sole arbiter of the law, and if the elements of the law are not present, or Your Honor doesn't believe the credibility of a certain witness, that's completely within the purview of the court. And so whether that runs along with trial, those decisions, the court's decisions run along with trial, or are heard in a separate hearing, are of the very same matter. And we could have said, Your Honor, we'll choose to run the suppression along with trial. And if Your Honor would have said, okay, then that's how we would have done it. We'd be doing it today, but within the framework of a trial. that would not be a decision. Suppression issues would not be a decision jurors would make. That would be still the court. However, Your Honor granted a separate motion to suppress, which the court is absolutely inclined to do. And in fact, the defendant has the right to that. So we're here today to have the court hear the issues in the motion to suppress and have the court rule on those. And again, I would respectfully ask that the court deny the state's motion.
State, anything further?
Yes, Judge, just, I believe that Mr. McElroy does have it. My understanding for trials is that trials in this court are to begin on Tuesday, so it wouldn't have been Monday. Tomorrow actually would have been perfectly sufficient, 3 business days notice, but that is not what has happened.
And Judge, the case was called for trial on the 18th, and what the court's scheduling policy is, or however you want to quite frame that, however the court decides to schedule cases, doesn't fall under the, in essence, the Code of Criminal Procedure doesn't dictate the court's scheduling procedures and policy. If the court, the case was technically called for trial on the 18th.
State, anything further on this matter? And this motion for continuance.
Nothing further from the state, Your Honor.
Defense?
Nothing from the defense either, Judge.
State, your motion for continuance is denied.
Thank you, Judge.
The court is scheduled to begin this trial tomorrow, as the state has pointed out. The however, and the reason the court is scheduled to begin a voir dire tomorrow is because of COVID situations, in that is when the jurors are available. However, I have just been informed there are insufficient jurors for tomorrow. Something that we have time to time looked into. Further, So, we may proceed in one or two ways at this time. To run the motion to suppress with the trial, or proceed to go ahead and hear it today. I will not be the jurist hearing the trial if in any way we can rustle up a panel of jurors tomorrow. The chances of that, I am not 100% sure, but I have received information that we do not have sufficient jurors. So at this time, I am going to suspend the record, and I am going to allow the defense and state to confer on this information I have just shared with you. We're going to suspend the record. Please go ahead and mute the court TV so the defense and state can confer. Defense, are you the only person there?
Judge, can you hear me now?
Okay,
Okay. No, Judge, I'm here. Both prosecutors are here, the court reporter and the deputy.
okay. So are you ready to proceed?
Judge, the state and myself are talking about some particulars that may resolve this case today. I would need to speak to my client, and I think we might be able to, well, and the case wouldn't be resolved today, but it would be on the track to being resolved. Without the necessity of trial, Judge.
So how do you wish to proceed?
What are my options, Judge?
Well, what are you need to speak with your client?
Yes, Judge, I would need to do that first.
Okay, alrighty. Do you have the device in order to go to the jury room so we can get you on Zoom and get you
Yes.
into the breakout room with your client?
Yes, I can do that, Judge. I
Okay.
would just, let me make sure I've got I would need the Zoom code is what I would need, Judge, because I don't think I have that for today.
Okay,
Okay, the deputy's gonna set me up, Judge.
all right. Isn't the deputy back, isn't the witness back there in the room?
Yes, Judge, but maybe with the state's permission, the witness can go into the hall.
Okay,
What's that? Yeah.
Defense, I would think that if you have your device, if you can go into the jury room, I think that would afford you more privacy.
You know what, Judge? Jaime, you can hear me, correct?
Yes, I can hear you.
Okay, are you on your
Um,
phone or are you on
okay.
a computer?
On a laptop.
Okay, if I text you, let me know if you can see this. Judge, I want to be able to resolve this without even getting online. But give me 1 second.
Why don't you go into the jury room and then that way you guys can talk on the phone? Defense, you're back.
Yes, Your Honor, I'm back.
Alrighty. We're getting back on record. And cause number 676-104, State of Texas versus Jaime Trevino III. State, are you ready to proceed?
State is ready to proceed, Your Honor.
Defense?
Yes, Judge, ready to proceed.
Alrighty. At the time that we suspended the record, I gave the state and defense an opportunity. I provided the state and defense some information regarding the availability of jurors and then gave them an opportunity to discuss how to proceed. I also mentioned regarding the possibility of running this motion to suppress with trial. And I have also looked into the availability of the jurors. And I need to go ahead and provide information if I am in need of the jurors tomorrow. Your case may not be the only case that's set, so I believe that we will, but I'll look at that once we settle with this case. We came back and this defense indicated that in conferring with the state, something has arisen whereby this case may be resolved. So, defense?
Judge, yes, the state and the defense have agreed to the terms of a conditional dismissal.
State?
That's correct, Your Honor.
And defense, you have accepted those conditions?
Yes, Your Honor, and I've discussed them with my client and he also accepts them.
State, what are the conditions?
A $200 donation to the San Antonio Food Bank, DWI Education, and uimpact.com.
Defense, those are the condition, that's your understanding of the conditions?
Yes, that is what we've agreed to, Judge.
And so how long will it take for you to be able to go ahead and complete this?
Judge, if we can give my client until September 30th, that would be, let's see, 40 days. By September 30th, he completes this.
Why is so much time necessary?
Judge, I'm just erring on the side of caution. My hope is that he has this done within the next week or so, but just in case as things come up, I want to make sure that he is able to successfully complete it.
Judge, the state is not opposed to Mr. Trevino completing the conditions by September 30th.
12th September, does that sound doable?
If that's the court's order, then absolutely.
Okay, all righty. Now understand this, that if the conditions are not completed and the court and the proof of those conditions are not emailed to the court, not e-filed, with a copy to the state, of course, that Mr. Trevino III will plea on the 12th of September.
Okay, did you say to e-file the proof of completion?
Proof of completions must be e-filed.
Okay,
And the donation will be to the Therapeutic Justice Foundation.
Therapeutic Justice Foundation.
Yes.
So I'll get a new picture of it. Just I'm gonna forget what that is.
So you understand that on the on or before the 12th, if I do not receive the proof and the dismissal, defendant will plea.
That's understood, Judge, and I believe my client understands that as well. Hamid, you understand that, correct?
Okay.
Yes, Your Honor.
Now, second thing. I will need a jury waiver. Effectively today. My court coordinator is there, should be able to go ahead and get you one. So that can be signed, and I'll need for that to be I believe Adobe signed, and I can get that today.
Judge, if she has it, can I sign in person since I'm here, and is a signature of counsel alone sufficient?
No. I will, no, it isn't sufficient, and I will let you confer with the court coordinator. She should be right around the corner in the chambers, okay?
Okay, we'll get that done then.
All right. Anything further on this matter, State?
Nothing further from the state, Your Honor. Thank you.
Defense?
Now from the defense, Judge.
All righty, you guys are excused. Thank you very much for your time.
Thank you, Judge.
State, if you will go ahead and jump back on Zoom once you get to your office.